Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing common law marriage and the legal issues that can arise from that type of relationship. When does a relationship turn into a common law relationship? And how do the legal rights of common law partners differ from the rights of married spouses? What should people in common law relationships do to protect their legal rights, both when things in the relationship are going well and when things are on the rocks? Here today to discuss this are two legal experts. Jess Polis and Ella Ayase are family lawyers practicing in Ontario. Thank you both so much for joining me today. Jessica, let's start with the basics. When does a relationship turn into a common law relationship?
Thank you for having me, Christine. It's a pleasure to be here. So the answer to that is actually more complicated than you would think. There isn't one specific definition of what a common law relationship is that applies across the board. The most common definition that we look to is the one in the Family Law Act, which is specifically in reference to when does a relationship become a common law relationship for the purposes of determining entitlement to spousal support. And that is when the parties have been residing together in a conjugal relationship for a period of 3 years, or when the parties have been living together for a period of at least a year if there are children involved. But again, that definition is sort of very specific to spousal support. When we're talking about what is a common law relationship for the purposes of benefits or under the Income Tax Act or in other areas, that definition can be very different. So it
Yeah,
is an
so
interesting and
so
confusing area.
so Ella, how much wiggle room is there in that relationship? Say a couple is just short of that 3-year threshold, or there's some debate about what it means to live together continuously. How much flexibility is there in that definition?
So I would say there is some flexibility, especially the Court of Appeal and also the Supreme Court of Canada have ruled in the past that the definition of cohabitation, like sometimes you have relationships that are of some length, but there's intermittent areas or times of cohabitation. So we have to look at the whole relationship as a whole and fact specific. And obviously, as lawyers, we always believe we can argue a nuanced and a new area of law or definition into the system. So, and that's why we have the tradition of common law in Canada, which allows judges to look at the facts of each specific case and provide maybe a new definition or a new explanation as to how that relationship can be defined. So, just to answer your question very briefly, there is wiggle room. But it has to be something that's argued and proved on evidence, and so it is fact specific. There's a clear cut answer, but we will look at the permanency of a relationship to
Now,
see if there's wiggle.
Jessica, can you be in a common law relationship if you were still technically married to someone else? For example, it takes a period of time to have your divorce finalized, even after a relationship has ended and there has been a period of separation. If you are then move on and are living in a home, living together for a long period of time and have not finalized that divorce, does that impede in any way in the ability to have a finding that there was a common law relationship there?
So you can absolutely be still married, particularly. A lot of couples wait quite some time after they've separated before getting a divorce in place. So you can absolutely be still legally married and in a common law relationship with someone new. And you may have spousal support obligations to both of those people potentially. So absolutely it is definitely possible. And as Ella said, every relationship looks very different and the law does try to account for every situation, but it's very difficult. And that's what adds that level of nuance and gray area. So to answer your question, yes, you absolutely can.
You, I guess that's sort of like having two spouses at once. I didn't know that you could do that, but I guess you could have a spouse you're separated from and a common law spouse simultaneously. So we've got to go to commercial break now, but in the next segment, I want to talk about some of the major differences between common law rights in common law relationships and rights in married spousal relationships. And I think some of those big differences might relate to things like the matrimonial home, division of property when relationship ends, and things like spousal support. And as well as we can get into child support as well. We've got to go to break now, but we will be right back to talk about those topics and more. Welcome back to Canadian Justice, where we're discussing the legal issues around common law marriage. Now, Ella, there are some pretty big differences between the legal rights of people in a common law relationship and people who are married spouses. At a high level, what are some of the biggest ways that those relationships are different?
I would say basically it's defined by the Family Law Act, at least in Ontario, where there's a clear legal and default rights that are applicable to married spouses, legally married spouses, that does not include or extend to common law spouses. So you start with Part 1 of the Family Law Act, which is all about property division, exclusion, and the definition of the matrimonial home under Part 2 of the Family Law Act. And for those two sections, we don't consider common law spouses in the definition of what a spouse is. However, having said that, again, we are a nation of judge-made law, which is called common law tradition, and judges have found principles in equity or judge-made law where they allow for division of property between common law spouses through claims such as unjust enrichment, joint family ventures. But those are very difficult to prove, and they do require potentially going to the court to just prove that entitlement, whereas for married spouses, it's right there in the act, you're entitled to it, and it's a much simpler starting point for property division for married spouses.
So it seems to me one of the biggest differences has to do with the home, which for most people in Ontario and in Canada is the largest asset that they own. In spousal relationships, that's called the matrimonial home, but in common law relationships, it is treated differently. So Jess, is there anything you want to explain about how it's treated differently? If a couple is married together or living together, not married, one of them owns the home and the other does not, and then the relationship falls apart without any cohabitation agreement, and we'll get to cohabitation agreements a little later, but what would the baseline treatment be in cases like that?
Yeah, absolutely. So it is definitely different. So for married spouses, there is under the Family Law Act what's called a possessory interest in the matrimonial home. So that means that even if the home is owned by one spouse, the other spouse has the right to continue residing there. And then in addition to that, as Ella said earlier, married spouses are also subject to the property division regime, which means that what they're entitled to is it's called equalization of net family property. And what that essentially means is the parties are entitled to share in the net worth that they accumulate as a family, whether that net worth is being accumulated in one person's name or in joint names. Both parties are entitled to share in it. When it comes to common law spouses, they don't fall under the definition of spouse under the property or the matrimonial home sections of the Family Law Act. So they don't have the same possessory rights to remain in the home, and they don't have the same right to share in that net worth that is being accumulated by the family as married spouses do. That being said, and again, going back to what Ella was saying, there are equitable claims that can be advanced, like trust claims in the property, like joint family venture claims. And when those claims are advanced, they can also put a pause on the spouse who owns the property's ability to, for example, evict the other spouse from the home. But it's all much more gray and much more difficult to prove and enforce than it is for married spouses who are just automatically entitled.
Now, Ella, we've only got about a minute and a half left. At a high level, one of these ways to make this claim for the house in a common law separation is through something called a constructive trust. Very briefly, what does that mean?
Constructive trust basically means that you have a beneficial interest, an ownership interest in a property without being named on title. So legally, it's not registered under your name, but through years and years of contribution to capital costs such as mortgage payment, property taxes, home insurance, you now have developed an interest that's akin to an owner's interest because you have been behaving like an owner would do towards that property by maintaining it and preserving it through your financial contribution, or as well as through your labor of like maintaining the home, performing repairs to it. Anything that adds value to that home can later on be argued as actions and contributions, whether physical or again by through labor work, to show that through usually a longer period of time, you've now gained an interest. So
Right.
you would have to claim unjust enrichment, which can be remedied by the court finding a constructive trust in favor of that
But
person.
again, not automatic, something you would have to argue in court, unlike in the case of spouses. Welcome back to Canadian Justice, where we're discussing common law relationships and what happens when they go wrong. What are the rights of the parties involved? Now, one of the things that I think a lot of people might not know about is the concept of a cohabitation agreement between common law spouses. Just if a couple is living together, they're in a common law relationship, but perhaps maybe the home is owned by only one of them, why would signing a cohabitation agreement be a good idea?
Going back to what we were discussing earlier in terms of this concept of a constructive trust claim, by entering into a cohabitation agreement, the parties are able to more clearly define what they actually want to happen in the event of a separation, or even in the event that one party should pass away. So entering into a cohabitation agreement is a really good idea when parties are deciding to live together, because it can get rid of some of this gray, confusing um, lack of surety as to what's going to happen should they separate, should a party pass away. So with a cohabitation agreement, you can specify whether it's your intention for someone to build equity by making financial contributions, or whether it's the intention of the parties that the person who owns it is going to be the exclusive owner, and regardless of any contributions, that won't change.
So, Ella, if the two people in the relationship own the home jointly, both their names are on title, and they made, say, an equal contribution in mortgage and down payment, should they still get a cohabitation agreement? What would be the benefit of a couple like that getting a cohabitation agreement?
So, as Jess was saying earlier, the cohabitation agreement can talk about different property entitlements a spouse can have or could gain through the cohabitation agreement. If you own a property jointly and you contribute jointly in equal shares, you are protected by property laws, but your protection only extends to that one property alone. But it also doesn't protect you from potential claims by the other side. Sometimes a 50% owner can try to gain a further share than their 50% by taking a share of yours. So a cohabitation agreement can make all of those points very clear as to what is the intention of the parties, the spouses, when they're dealing with their common property. Is it to join and share it equally, or is one person entitled to a bigger share of the proceeds of sale upon a sale, or how would a sale happen? Does one party have a right of first refusal to buy the other party out? So those are some of the important things that a cohabitation agreement can address, so that you prevent having to go to court over it and trying to try different arguments, present evidence to prove your point. So it's good to always codify your, not codify, but just to clarify your intentions at the beginning in a cohabitation agreement.
Jess, is there anything you want to add to that? Any types of things that you recommend putting into cohabitation agreements?
Yeah, absolutely. Just to expand on what Ella is saying, I think it is very important for parties, and I think a lot of people don't do this, but I think as people are starting to live together, or even when they are planning to get married, it's so important for them to sit down and actually talk about how they want to financially structure their family finances, their future. And I think that's a conversation that people don't have as often as they should be. And I find that when entering into a cohabitation agreement or marriage contract, those conversations have to happen, because we are at that point working together to put it all in writing. And I think that's a really beneficial thing for a lot of couples to do entering into any kind of relationship. To expand as well as in terms of what you can address, in addition to property claims, you can also address the concept of spousal support, whether there's an intention for the parties to potentially support the other person based on, different family dynamics. If one person's intention is to take time off work to focus on child rearing or make other kinds of sacrifices in the relationship, those are things that can be addressed with respect to spousal support. And having that really set out in a cohabitation agreement prevents a lot of arguments down the road.
Now, Ella, last question. We've got about a minute left. When people enter into that cohabitation agreement, should both parties have their own lawyer? Especially if things are in the relationship are good, could the couple share a lawyer or even have a mediator create that agreement, or does it have to have everyone has their own representation?
I definitely recommend that each party have their own lawyer. Can they have a joint lawyer? Yes, but I would argue that there could be a lot of conflict arising from that, because if you think about any marriage or common law relationship, is the coming together of property and income. So once you're separating, how you divide that,
Right.
there's going to be a certain pool. So if one person gets $10,000
Right.
more, the other person gets $10,000
Right.
less, and there's always going to be a
Right.
conflict.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing common law relationships and common law separation. Jess, we were just in the last segment talking about the process for entering into a cohabitation agreement, which can add a lot of clarity before things, end in a common law relationship. Is there anything you want to add about that process?
Yeah. So just to expand on what Ella was saying, while you can, hire a mediator or something like that, the reality is the best way to enter into a cohabitation agreement is for both parties to have independent legal advice and for both parties to really do their full financial disclosure. And part of the importance of both parties having their own independent legal advice is to ensure that there's no issues of duress or power imbalances between the parties entering into the cohabitation agreement. That process is really what's going to be key to ensuring that a court down the road doesn't just decide to set the whole thing aside and you're sort of left back where you would have been without it in the first place.
Right. Very important advice. Now, we've been talking a little bit in the last segment about spousal support. So, under the law, under the statutes, are there obligations for spousal support between common law partners when separating? And if not in the statutes itself, can that be established through court decisions? Jess?
So yeah, definitely common law couples are, while they're not privy to the property regime, they are privy to the spousal support regime. So common law couples absolutely do have the same rights to spousal support as married spouses. And even when it comes to married spouses, if the parties, for example, cohabit for a period of time prior to marriage, that period of cohabitation is included when we're looking at the duration of the relationship.
Wow, interesting. Now, one of the other questions I had is about liability for debts. Now, I know that there are situations when you can be liable for your spouse's debt. What about your common law partner? Are there situations when common law partners share one another's debts, perhaps even when they didn't sign on to them themselves? Ella?
Thank you. Yes, so I would say that's one area common law spouses can get away with, because debts and being liable for a debt, unless it's through a statutory provision, it's going to be very, very hard to construct the fact that somebody is liable for a certain debt. So you need to sign on it. You need to co-sign a mortgage or a line of credit to be liable personally on that debt. So unless there's a provision in the statute saying that by definition of being a common law spouse, you share debts, you really don't. And even under for married spouses, while people share debts in the sense that they reduce how much they take away from the wealth accumulated in the marriage, it's not like direct liability for a debt. It's very difficult to establish. I think there's very specific areas such as income tax liability that could apply to spouses, but to extend a liability to a spouse, it's very difficult. So it's going to be very difficult to establish it in case of a common law spouse,
But
unless there's
in terms of tax liability, there can be liability there.
For married spouses, yes.
What about for common law spouses?
Not that I know of.
Okay.
I mean, I'm not a tax expert, so but maybe Jess can correct me if I'm wrong. But I don't believe there's a common law tax liability for spouses.
Um,
I don't
now,
believe so either.
now, Jess, we've got about a minute left. Courts treat and statutes treat common law partners differently from married spouses. That's what we've been talking about. What's the policy reason for that? What's the rationale?
So, I mean, as we know, the law is slow, and historically, married spouses were treated very differently than common law spouses. We didn't really even have that as a concept. So, I think the law is slowly catching up, and that's why, changes with respect to spousal support have been enacted. When it comes to the property regime, though, I think there's still an idea that when people are entering into a marriage, they're thinking about and accepting some level of coming together financially. That I don't know that the law has decided common law couples are necessarily doing in the same way.
Right.
Whether that's a correct policy or not is a different issue, but I think that's sort of the rationale.
That's all the time we have today. Thank you both so much for coming on.
Thank you.
We've heard today about the different ways the law in Canada treats marriage and common law relationships. If you are in a common law relationship, did you know about these important differences? And how much have you done to protect your legal rights? And what is your view of the policy rationale for treating marriage and common law relationships differently? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.